With please, Lordship.
Yes.
Lordship, with seeking apology, Lordship, and with the consent of the appellant side, Lordship. In item number 2, my Lordship directed us to file affidavit, Lordship. We have received instructions, so Lordship may fix after vacation, Lordship. In the
You
meantime,
just let the matter be called out. You'll see.
Lordship.
May I please, Your Lordship? Item number 20, Your Lordship. This is a fresh admission appeal. May I pray for taking up Monday, Your Lordship, this matter?
Why? What happened?
Your Lordship, yes, I have reached Guwahati today, Your Lordship, morning.
You're not prayed for stay, then let it come up after break.
Your Lordship may.
Then what is the urgency?
Urgency in the sense, Your Lordship.
Because you have not prayed for any stay.
Lordship,
So then what is the urgency? Let it come after puja vacation, if not that.
Lordship.
Place after puja vacation has prayed. Date the 7th November.
Lordship, for item number 15, 16, and 17, matter may be adjourned for the day, Lordship.
Why?
Lordship, complete legible copy has not been served yet.
We will serve it.
And counsel for the respondent submits that legible copies of the rate appeal and the annex documents annexed to the rate appeal has not been provided to her, Mr. Gupta, to do the needful, re-notify after 2 weeks, after 3 weeks.
Obliged.
May I please, Your Lordship, we have
Yes.
filed an arbitration appeal. The matter may kindly be listed on 17th of October.
What have you filed?
Your Lordship,
What have you filed?
we filed just the day before yesterday.
What? What have you filed?
Oh, arbitration appeal, Your Lordship.
Arbitration appeal.
Yes,
Does it
Your
come here? Check. If it is in roster, all right, list it. List it as per roster. Simple. You have permission accordingly.
May I please, the Lordship? My Lord, the petitioner before your Lordship are, my Lord, in-service doctors, my Lord. They were, my Lord, selected, my Lord, in the my Lord, entrance for the, my Lord, post-graduation course, my Lord. And accordingly, my Lord, they were called for, my Lord, counseling, my Lord. And in the counseling, my Lord, the third round of counseling, my Lord, there was, my Lord, irregularity, my Lord.
They were?
There are, my Lord, the serious irregularity committed by the director, my Lord. Therefore, my Lord, they were deprived from the, my Lord, proper, my Lord, counseling of the third round, my Lord. Now, my Lord, the matter is gone to the, my Lord, last round, my Lord. And we prayed, my Lord, learned single judge, before the learned single judge, that, my Lord, we are, my Lord, as our, my Lord, third round is vitiated in law, my Lord, apparently, my Lord. So, my Lord, third round may be held, my Lord, properly, my Lord. Then, fourth round. may be
What
taken.
happened in the single bench?
My Lord, single bench, my Lord, our, my Lord, third round, my Lord, was not rescheduled, my Lord.
So your writ petitions have been dismissed or they are
My
pending?
Lord, only notice was issued, my Lord.
So then, all right, what can we do?
My Lord, we are praying for, my Lord. Otherwise, my Lord, we are, my Lord, seriously prejudiced, my Lord. If, my
What?
Lord, our,
Can you file an appeal against order issuing notice?
my Lord, there are observations given, my Lord, and my Lord, matter is fixed in the next month, my Lord. Matter is in fact.
I don't think so, sir. This writ appeal
Kindly, matter,
doesn't seem to be maintainable.
my Lord,
Doesn't appear that your writ petition is maintainable.
my Lord, Monday, my Lord, Lordship, kindly consider.
But we don't find, well, all right, give us your file. Give us a copy of your petition. Where is your,
My Lord, I am just being filed, my
so
Lord.
being filed, you can't ask for permission, sorry. You have to file and thereafter come.
My Lord.
Okay.
Deep Lord.
May I please, your Lordship, I think indulgence of your Lordship for listing of a writ appeal, my Lord, the matter pertaining to the MBBS admission matter. Earlier we were granted admission, then pursuant to the order of the learned single judge, we were after, wherein we were not made a party by.
Monday.
Wait, Monday, obliged, Lord.
May I please, Your Lordship?
We have ordered two. Let them.
Yes.
May I please, Your Lordship? Lordship, with the consent of the other party, I have explanation item number 29 of today's Lordship. I am appearing on behalf of A. Soma, Lordship. He has some personal difficulties today. Kindly fix the matter after.
The council, the appellant prays for time. The other side, who is there for the, does not have any objection? List of 4 weeks as paid.
Therefore, listing a matter on next week, Lordship.
What is the matter, sir?
Regarding the removal of a chairman of Jila Parishad.
Nothing, no urgency. Let it come up for application.
Please, Your Lordship. Your Lordship, withdrawal IA has been filed yesterday to be listed on Monday.
Withdrawal IA,
Yes.
withdrawal IA Monday, Tuesday.
Lordship. Maybe on Tuesday, my lord, my senior has to appear, my lord. We have got a petitioner respondent, maybe on
Tuesday only we have granted. Yes.
May I please the Lordship? Well, just I have received, my lord, the table already filed, my lord, Monday may come by.
All right, get it listed on Monday. Diploma. So all right, they go there and in this subject to the writ appeal being maintainable, the office has to examine, yes. You don't find that the put it in the market in this slip, subject to being maintainable. Yes, yes, yes.
Daily list for orders, item 3 and 4.
Service not complete.
Yes, Your Lordship, we have already taken
Steps have been taken for effecting service of the respondents on 4th October. Let notice be issued. Why it has been listed? Or what is the office note?
Lordship,
You have not issued notices. The notice was issued on 4th October. They have listed it again on 13th. Is this nonsense? Office notice of 10th. Obviously, the time for notice has to be given. Await return of notices for 4 weeks.
Item number 5.
Lordship, we have filed our affidavit. We have sent notice for justice service, Lordship.
Affidavit in proof of the service has been filed. No one puts in appearance on behalf of the respondent despite service. Lists the appeal for admission after ensuing puja break. In the meantime, the standing counsel to apprise the court regarding the proceedings which might have taken place as a consequence of the order passed by the ITAT.
Item number 6 to 8.
You have filed an affidavit on 19th September, right?
Your
What is that?
Lordship, in PIL 2, on the
First,
last.
you are arguing the PIL 2 first?
Yes, PIL.
PIL 2. PIL 2 then. Yes. What is the prayer in PIL 2?
In PIL 2, Your Lordship, the government actually failed to come up with a transgender welfare board as well as a state level transgender protection cell under the DGP. So Your Lordship, on the last date, Your Lordship had asked me to find some of the other details of the other state government, what they did pertaining to the setup of the welfare board as well as state level protection cell under DGP.
So Mr. Nath had conveyed that they have already taken steps for constituting the board. What has happened thereafter?
They have taken the step for the constituting the welfare board in a newly manner, but simultaneously including a gay person in the post of associate vice chairperson.
But you have to challenge that
Now,
appointment.
what is the sanctity and the veracity of that person? What he did?
You should try to understand that you have to bring out a specific challenge
Yes.
to his appointment.
But your lordship, let them come up with an affidavit and placing it on record, the notification for the newly constitution of the welfare board,
Mrs.
so
Nath,
that we can
yes,
come up.
where
with
is the
a-
notification?
Earlier it was under the social welfare department, I appeared. Now it is under the social justice and empowerment. They have issued the notification. My friend appears for that department.
They have issued.
They have-
So this is 1st August. Why it has taken so long?
No.
Bring it on record.
Earlier there was a vote, no? It was again, placed.
So board has been constituted by, we have been time and again adjourning the matter for this purpose only.
It was tactfully been done by the other side.
Malad, an affidavit, page 9, it was earlier constituted on 19th of May 2020. We have filed the affidavit on behalf of the social welfare department at that point of time.
It's not now in the recent past.
Now,
We have been telling you time and again what is happening. This 2 months ago, 2.5 months ago, you issued the notice.
but now my friend appears for that. department.
Now,
I'm not-
earlier you were there.
Earlier,
So this is the notification of 2000 August to 1st August.
August 31.
Then,
But the department was bifurcated a few months back. My friend is appearing. Malad.
so why it was not brought on record?
Here, it has been informed, but the notifications were not produced before your lordship.
So that is what we are asking.
Moreover, regarding the setting up of office for the transgender welfare board, we have written to the associate vice chairman of the transgender regarding her requirement, lordship. This is the list, lordship.
You have a copy of this notification. We are giving you.
I have somewhere collected from the other community.
If you want to challenge the appointment of any particular,
I will.
you will have to take pleadings and also implead.
Yes, your lordship.
So what do you
I will
want
be allowed
now?
To file a IA in this.
Yes, you will have to do that. So what do you want presently?
Your lordship will find that before constituting a newly members in the board, they have to call for a board meeting. They have to take a resolution. The previous board has to be dissolved.
File the pleadings accordingly. We'll take note of those.
Yes.
Orally, we can't do anything. No? On oral submissions, this is not possible. Current counsel for the, you are for the Social Justice and Empowerment
Lordship.
Department. Your good name, sir?
RM Das, sir.
RM Das has placed on record copy of the notification dated 1st August 2023, as per which, 6, an associate vice chairman, chairperson, and 5 members have been incorporated. Members of the transgender community have been purportedly incorporated in the Transgender Welfare Board. A letter dated 7th August 23 issued by the Director, Social Justice and Empowerment has also been placed on record, as per which, a sum of rupees 6 lakhs has been released by the Finance Department for setting up of the office of the board. Current counsel for the petitioner vehemently and fervently urges that the composition of the board was undertaken in an illegal manner, and some of the members are not even entitled to be a part of the board. She proposes to file interlocutory application to bring on record these objections. List on
Any date after vacation.
whatever date you want. We are leaving it to you.
First week of November, your lordship.
9th November.
At the same time, your lordship will find in this PIL, the police has to come up with an instruction regarding the setup of
Yes.
state level protection cell.
State level protection cell. It's not.
Protection cell, in our affidavit, we have said, kindly take the affidavit of Mr. Respondent number 6, by Nitul Kogoi, on 19th of August 23. We filed.
Yes.
Annexure A, page 71, in exercise of Rule 11.5 of the Transgender Persons Protection of Rights Rules 2020, the Governor of Assam is pleased to constitute a state-level transgender protection cell with the following, to monitor cases of offense against the transgender person and to ensure timely registration. This is the cell block.
Your lordship may kindly see page 73 of this affidavit.
Yes.
Page 73, the composition here, DGP, ADGP, Commissioner of Police, DIGP, someone Srimati Ambalika Senapati, a member. But nowhere a trans representative is there in that committee.
It was.
Which is a clear violation to the advisory recently passed by the NHRC. Your Lordship, I have given the soft.
Bring everything on record by right in your IA and the affidavit.
Yes, yes.
That Mr. Nath submits that a state level protection cell has already been constituted. However, the petitioners council constituted, and this fact is elaborated in the affidavit dated. But what is the date of the affidavit? Because pagination is not proper. Nitul Gogoi,
Nitul Gogoi, my lord.
affidavit filed by one Sri Nitul Gogoi on so and so. However, the Land Council for the petitioner has serious objection to the composition of this board, urges that the guidelines issued by the NHRC have not been followed while constituting the board.
Here
Yes.
is this PL only, Your Lordship, that stripping of cloth of
Stripping
the-
search, strip
that was
search.
done.
What have you said about that?
In my affidavit in reply, I have annexed those.
So that reply I have not received, my lord. My lord, that copy of the reply, if I get, my lord, I'll definitely take the.
Give a copy. of it. Till date, comma, Mr. Nath has not responded to the observations made by this court based on the oral submissions of the petitioners council, which have subsequently been incorporated in the affidavit in reply, dated 8/8/23,
8/8/23.
that the transgenders apprehended with accusations of crime are being strip searched in the police station. The copy of the affidavit in reply be provided to Mr. Nath. The requisite pleadings and additional affidavits, if so required, be filed by the next date, list on 9th November.
No, my lord.
What about the other two?
Your Lordship, in PIL 6,
Yes.
it is pertaining to the discriminatory advertisement of the Assam Police, where they have included they have mentioned the transgender persons, but none of them were allowed. Because the process.
They have placed on record a letter which says no one applied.
Your Lordship, for application, for applying also, there should have some evolving principles that are not in accordance what the NALSA says and what the Transgender Act 2019 talks about.
Yes, Mr. Nath shall come out with a positive proposal of the state government to have a proper criterion to give opportunity, so as to give opportunity to the persons of transgender community to apply in the state services.
Your Lordship, may kindly for a moment, may see the advisory. I have given the hard copy.
Let's see the advisory.
Hard copy of the advisory
This observation is being made in reference to the advisory issue
of NRC,
by the
NHRC.
NHRC. Where is the advisory? Yes. Mukut, take it like this. The concept for the petitioner has also raised a grievance that the state of Assam is not providing proper avenues to the transgender persons for making applications in the selection processes being undertaken by the state government. It is contended that the NHRC has issued
It's a very recent advisory.
an advisory dated 15th September 23 regarding employment of third gender persons in the state services. Mr. Nath to take instructions and ensure that appropriate steps commensurate with the advisory are taken by the state government in the ensuing selection procedures.
Here, your lordship, in this advisory at page 2, if your lordship may just see for a second.
We have referred to the entire advisory. Let them have a look at the advisory. Then
The
they will come.
employment column at point Roman 5, it says a grievance redressal cell be set up in the organization
Hmm.
wherever there are employed to deal with the issues of transgender employees,
Hmm.
in which at least one
One
transgender
transgender
person
person.
may be included, wherever
So
it's
these,
possible.
these guidelines are recent. Maybe they have to evolve accordingly.
Yes.
That is the thing.
But the filings by the petitioner will be done before the vacations. So-
You have to do the filings beforehand.
Before.
Yes.
Sixth is the
The,
opening, lordship is
uh,
looking upon nine.
Petitioner, filings by the petitioner may be done before 20th October, so as to enable Mr. Nath to respond in time. Mr. Nath and Mr. Dash to respond in time. Okay, that takes care of 6. What about 52?
Your lordship, in this 52, it is a challenge made to the illegal composition of National Council for Transgenders. However, we have filed an affidavit as well. And your lordship, so far this matter is concerned, till the date of appointment and till now, already the constituency has been expired. So now they have to come up with a newly constituted
This
members.
matter has become infructuous. We may close it. No.
Yes.
As stated by, since this PIL lays a challenge, the petitioner through this PIL lays a challenge to the composition of the National Transgender Welfare Board,
National Council for
Council for Transgenders. The petitioner's council fairly concedes that the term of the council has expired, and thus for all practical purposes, the matter has become infructuous. Thus this PIL is proved.
But one direction may be given that they should come up with an
We hope and trust that whenever steps are taken for composition of the constitution of the fresh council afresh, the guidelines prevailing shall be followed, strictly adhered to. Okay, close.
Item number 9.
Senior designated. She is wearing a senior gown.
May I please your lordship, further time may be allowed for filing necessary application.
Affidavit
Yes,
and
lordship.
counsel for the petitioner pays for and is granted. Further opportunity of. You have to file the application for substituted service.
Yes.
To move the application for substituted service. 3 weeks.
I look like.
Item number 10.
Wait, please, lordships. Because in this matter,
This before another bench.
Yes.
Of which Honorable Justice it is not a member.
Item number 11.
Yes.
Lordship,
Service is complete.
Yes, sir. Lordship can.
As per the. Do you need to rectify your cost title?
There might be a reason to. There might be an occasion to rectify the cost title also.
That is really unwarranted.
In
When
fact,
did you file the petition?
2022, your lordship, before.
So then you should have done it beforehand.
Yes, we-
Counsel for the service has been effected on the respondents and counsel for the petitioner to rectify the cost title. Because during pendency of this writ petition, one of the impleaded respondents has been elevated as an honorable judge of this court.
Yes. I'm grateful. Lordship.
List for admission. What is the IA about?
The IA, your lordship, the initial recitals in the writ petition, respondent number 7, your lordship, was engaged in a separate function, your lordship. Is the principal court of the family court, judge of the family court. Thereafter, during the pendency, your lordship, he had changed, your lordship, and thereafter,
Why, what for you have filed the IA?
this IA is for change of address, your lordship. Initially, the address. was-
Okay, so you file the amended cost title
Yes.
otherwise also,
Yes, your lordship, we'll do that.
after the needful is done, let the writ petition be listed for admission.
Okay.
Item number 12.
Yes.
Finding this writ appeal, there is a delay of 78.
78. Any objection? Delay of 78 days, no objection by respondents. Application allowed. Writ appeal be numbered and listed for admission.
Copy might be provided.
Copy of the writ appeal be provided to Learned Council for the respondents.
I'm so obliged.
Item number 13.
One zero three three days.
Yes, your lordships.
No cause to condone delay.
I have explained it.
Absolutely no.
I have explained it. 2018, the order is passed. I have been in all forward postings. I have been in postings which have been in Manipur, Nagaland. I have not been able to come back on time. There has been an occasion that I have also been posted in Kashmir.
Want to file reply?
I have a case on merit. That's why I'm
Council for the
requesting
respondents. Union of India, pressed for time, desires to file an objection in this IAS seeking condonation of delay of 1033 days. Occasion in filing of the connected writ appeal. When did he superannuate?
2000.
He is 62. So what has happened for the last 2 years?
He's gone back to his hometown.
You can't explain 2 years, last
No,
2 years.
I have explained, your lordships. All I'm saying is that after his superannuation, he went back to Tripura. He's contacted lawyers. He's not got the right advice.
That's not a ground, sir. That's not a ground. Absolutely
I
no.
will try to persuade your lordships on that. All I'm saying is that there is a.
Let them come out with the objection.
I'm
We'll see
grateful.
then.
I'm grateful. Obliged.
Hmm. 4 weeks. कर दें.
Item number 14.
Made his lordship. This is a reference made by learned single judge for deciding a question. as to
There's
whether,
now reference has been made by Honorable the Supreme Court also.
yes, lordship.
Yes, yesterday only we received the copy. This reference has been made by learned single judge of this court on the question whether an application for pre-arrest bail lies or not when accusation is made against a person who is juvenile covered under the provisions of accusations of the crime is made against the juvenile covered under the provisions of the Juvenile Justice Act so and so 2015. The registry has pointed out that identical controversy is Honorable the Supreme Court is in session of an identical controversy in special leave to appeal within bracket criminal number 12659/23 Yuvraj versus State of Rajasthan. Thus, the consideration of this reference is deferred by 6 weeks. Let the Supreme Court decide. We can't now enter into that issue.
Item number 18.
Please, Your Lordship. Plus the list in the instant cases with regard to appointment to the post of LDA in a high school, my lords. But what had happened, my lords, apparently, my lords, the respondent number 7, my lords, who was an overaged candidate and who took the benefit of an OM for disability, submitted the disability certificate after the entire process was over. Although the learned single judge took cognizance of that fact, but nonetheless, my lords, the writ petition was dismissed on the ground that I had challenged the consequential order of termination of appointment, but not the orders prior to which the appointment letter was, only on a technical ground, my lords.
There's a substantive ground.
Yes, but in my
if the infrastructure fails, the superstructure fails.
I understand.
Plain and simple.
But my lords, there are judgments of the Supreme Court wherein the Supreme Court has held, my lords. If
Read the relevant part of the judgment. Let's see.
My lords.
Yes. Para 13.
Para 13, my lords.
Or rather, above that.
Yes, my lords. Sorry.
Come to para 11 onwards.
11 onwards. Para 11. Rejoining his submission, Shri Mahanta Learned Counsel for the petitioner submits this consequential order being put to challenge a writ court may mold the relief. He further submits that although adequate pleadings may not be there, in the writ petition, in the reply affidavit, an indication has been made regarding the grievance of the petitioner against the two orders. And in this connection, he relies upon the decision of the Honorable Supreme Court in last Sri Subramania Desika so-and-so versus State of Madras, reported in AIR 1965-1578, wherein the Supreme Court has laid down that new averments in a rejoinder affidavit may be made, which are to be treated as pleadings. This court has given its anxious consideration to the submissions advanced by the parties. What is intriguing in this matter is that after the remand order dated so-and-so passed by the court in WPC so-and-so, which was an inter parte one, the matter was examined by two authorities, namely Additional Deputy Commissioner Nagaon and also the Deputy Commissioner in charge, Hojai, in which both the parties were heard. And after a fact-finding inquiry, two orders were passed, respectively dated so-and-so, both in favor of the respondent number 7, upholding his selection. However, the petitioner has not chosen to challenge the aforesaid two orders, which are the root of the consequential order of appointment. This court is of the opinion that unless and until the initial orders leading to the consequential order are put to challenge, the present challenge would be an incomplete one. And even as a writ court, the power to mold the relief in the instant case cannot be taken into recourse. Now, my lords, in my humble submission, my lords, the Honorable Single Judge, that is correct, my lords. The orders were not challenged. But nonetheless, my lords, the Honorable Single Judge has taken cognizance of the fact, my lords, that the appointment was illegal. Now, my lords, the procedure, if it does not touch upon jurisdiction, my lords, the court in normal circumstances.
What was the earlier order passed by this court?
Earlier order, my lords, the matter was referred to the Deputy Commissioner to take a decision.
So that decision never challenged.
No, but the order of appointment was challenged. Now the, my lords, I'll just, my lords, point out.
The reasonings are assigned in those orders, Mr. Manta.
Yes.
The orders wherein the reasonings are given, not being challenged. Why should the subsequent order be even examined?
Lordship would issue notice to the respondent.
Not required.
In that case, may I just point out one thing? My lords?
Yes.
That apparent illegality, may I just point out? My lords would come to.
The the disability certificate is subsequent to the
Completion of the advertisement.
that may be the later certificate, but the disability was not subsequent. It was pre-existing.
No, my lord. In that case, my lord, if I may kindly satisfy lordship, may kindly take up the Persons with Disabilities Act, my lord. For a moment, kindly, my lord.
Read.
My lord,
Where is the certificate?
my
Let
lord, the
us see this.
certificate, my lord, would find at page 73, my lord. 73. Page 73. My lord would see the date, my lords, on 21/12/2015. Whereas, my lords, the date of issue, my lords, is at top right column, 31/12/2015. Date of the application was, last date of application was 18/12/2015, my lords. And written examination was on 20/12/2015.
Where is the recent order whereby this aspect was discussed? Post remand?
That was, although we pointed it out, but that was never taken into consideration by the Deputy Commissioner. My lords, the
Where is that order?
orders of the Deputy Commissioner, my lords, would find page 93, my lords.
Where is the order in the first writ petition?
Order in the first writ petition, my lords, would find annexure G, my lords, page 69.
Oh, come to page 80, para 9.
Page 80, para 9, my lords.
Yes. The certificate, he had filed a certificate, but that certificate had expired in 2012.
No, no.
Yes.
No, I'll
Come to
explain.
para 9.
I'll explain that, my lords.
Yes.
With regard, so this certificate, what he's referring to, my lord, that's a certificate issued by the Social Welfare Department, which cannot be used for medical purposes, medico-legal purposes, because the act is very clear, my lord. If I just point out the provisions of the act, my lord may be satisfied, my lord.
Let us see the order of the commissioner, the DC first. And you were to point out the High Court's order.
My lord. Deputy Commissioner's order, page 93, my lord. My lords,
And where is the order of the High Court, please?
order of the High Court, my lords, the impugn order, my lords.
No, the first order in the first round.
The first order, page 69, my lords.
Let's read that.
The relevant portion is the last paragraph, my lord, page 70. On the limited prayer above, this writ petition stand disposed of with a direction to the Deputy Commissioner to consider the representation of the petitioner and pass appropriate
Where
orders.
is that objection of disability certificate and the age relaxation in that writ petition? It was never there.
It's there, my lord.
Oh, read the order, please.
The earlier page. Page 70, my lords.
Yes.
I'll read it out, my lords. Assistant Dokhin High School person to the advertisement. The petitioner claims that he had secured the highest marks in the written test and computer test, but insofar as Viva was concerned, he was given, so that is not important, my lord. On the other hand, the respondent number 4, headmaster of the school, manipulated the marks that had been originally allotted to the respondent number 5 by a member. Also, as per the advertisement dated so and so, the upper age limit against the unreserved post was 38 years. However, the respondent number 5 was overaged over 40 years of, as on 1st of January 2015, his date of birth being so and so. Alleging anomalies in the selection process, the petitioner made a representation before the Deputy Commissioner, Nagaon, as well as the Inspector of Schools of the said district. Those representations were made on 5/2/2016. It is the case of the petitioner, despite being glaring irregularities in the selection process, the same having been brought to the knowledge of the Deputy Commissioner and the Inspector of Schools, no steps whatsoever has been taken until this date. A limited prayer is made that the said representations be looked into and necessary orders be passed. Now, my lords would come to the office memorandum by which he claimed, then I'll pay, my lords produce the law, my lords, then lordship may kindly take a decision, my lord. My lords would come to the office memorandum for a moment, my lords, at page 84. Admittedly, he was overage in my lords. 84. Raising of upper age limit for entry into state government services in respect of persons with disabilities from 38 to 43 years. As per provisions of 38B, the persons of disabilities so and so, Act 95, and after careful consideration of all aspects, upper age limit for entry into state government services in respect of persons with disabilities is raised from 38 to 43 years. Now, Lordship may take up the 95 Act because this memorandum has been issued as per the 95 Act. Now, Lordship would firstly come to
para 9 of the affidavit of the respondent number 7.
Yes.
Page 80.
Page 80.
The second para. Even the original certificate stood extended.
No, madam, that certificate, I'll come to that.
But there is no objection regarding that, sir.
I took objection.
Read your affidavit in reply thereafter.
My lord.
First, read the affidavit at page 80.
I'm so sorry, madam. That regarding statements made in paragraph 8 of the deponent begs to state that DC Nagaon, in compliance with the order of the Honorable High Court dated so and so, notice that both parties in presence of headmaster perused all documents placed before him by both the parties, and after hearing properly inquired into the matter and passed order by holding that the deponent, physically disabled person, nothing illegality was committed in this regard. It is to be noted that the deponent, along with the application form, submitted all required documents along with the disabled certificate to show that the deponent is a disabled person. Since the said certificate, it was mentioned that the same was valid up to 30/10. Well, I'll come to that certificate. 30/10/12, and also the deponent applied for up-to-date medical certificate. Accordingly, a medical board of 3 doctors of civil hospital was held on 21/12/15, and on 31/12/15 a certificate was issued after due verification of the body of the deponent, which was submitted the same to the headmaster of the school. My lords, the certificate 31/12, that was after the entire process was over.
Yes.
Now he's referring to a certificate which is 31/10/12. Now, my lords would come to that certificate for a moment.
Page 91. 91.
Page 91, my lord. Thank you. My lord, would see page 91 for a moment, my lord.
Yes.
Government of Assam identity card for person with disability. Next, my lord, district social welfare officer. My lord has seen that.
Yes.
My lord, is valid up to 30/10/2012. Now, what I say, my lord, with the deepest respect, my lords, even if this certificate was valid on the date of the advertisement, Even then, this could not have been pressed into service.
Where is that ground? Where is this ground in your writ petition?
Writ petition, I've taken that ground.
Read. Read.
It's a certificate issued by the Social Welfare Department.
Read, sir.
Well, I am reading. Well, I'm so sorry. I've taken it in my affidavit in reply, my lord.
Oh, that's good.
I didn't draft the well, there's a
That's
judgment, my
no
lord.
argument, sir.
Srila Subramanian.
No argument.
Even replies, my lord, it can be
Not in
considered as
these matters.
pleadings, my lord.
Not in these matters.
May I
Sorry.
just show the law, my
You
lord?
just said that he did not produce any certificate. That was your argument.
Yes, I agree. my lord. In the
The
affidavit,
certificate produced by the candidate was invalid in the eyes of law. There's no argument. No, nothing in your pleadings.
in the reply, my lord, I have
No, we are not considering that. You
affidavit,
can't build up a case in your reply. That's also settled law.
my lord. But the fact remains, my lord, that on the date of the application, he did not possess a valid certificate so as to,
Now let's read your affidavit in reply also.
yes, my lord.
Yes,
I will
page,
get to-
page 97 onwards.
yes, my lord.
Yes. Yes,
Yes, I'll just.
sure. Take your time. We have gone through this, your affidavit and reply.
That would regard.
No
to the-
submission at all.
Page 99, my lord, that with regards to the statements in paragraph 9 and 10 of the affidavit in opposition, the answer in report begs to state that Deputy Commissioner Nagaon completely failed to consider the fact that the respondent number 7 did not even have a valid disability certificate on the last date fixed, and
Okay.
as such was not even eligible to apply for the said post.
So how was that not a valid certificate? How did you demonstrate?
Yes, my lord,
No, in your pleadings, sir.
pleadings, I have not pleaded the law, my lord, because I've just
It's
pleaded the
not
facts.
law. It's not, it's a fact as to whether the certificate is valid or not.
My lord, I'll read further. Even in the paragraph under reply, the respondent number 7 has himself admitted that the same was issued only on 31/12/15 and was submitted to the headmaster of the school. As such, the acceptance of physical disability certificate, even after the last date fixed, shows that the intention on the part of the school authorities and the selection committee to somehow accommodate the respondent number 7 for the said post. In this count alone, the selection and appointment of the respondent number 7 to the post of LDA at Dakshin Hujai is liable to be set aside.
Yes.
Yes, my lord, the certificate, that 2012 certificate is a certificate by the Social Welfare Department.
Yes.
And as per the act and as per the office memorandum, a disability certificate has to be by a medical officer. my
The
lord.
medical officer has affirmed it later. Doesn't make any difference. Dismissed.
My
Thank you.
lord. Deeply honored.
Item number 19.
May I plead your lordship?
Yes.
Lordship, in this present appeal, the appellant has challenged the judgment and order dated 9/8/2023 passed by the learned single judge in petition number 708/2023. In the impugn order, Lordship, the Honorable Court, Lordship, did not consider the fact that, Lordship, though it has been discussed in the judgment, Lordship, but the termination order, which was produced before this Honorable Court on 15/3/2023, that was never been served to the Lordship present appellant. And till 15/3/2023, in fact, Lordship, petitioner has rendering service in the the appellant has also approached before this Honorable Court earlier occasion, Lordship, since her promotion has not been considered. And therefore, she approached before this Honorable Court, your Lordship will find at page number 92.
Read para 9 of the impugn order, gentlemen.
Yes, Your Lordship. It is also placed before the court.
And rather para 6.
Yes.
Yes.
In this petition, the petitioner has paid amongst other for a direction to the respondent in the Social Welfare Department to release the arrear and current monthly honorarium payable to the petitioner. 7, the petitioner in her petition itself admitted that after her initial appointment as Anganwadi helper of the Batamari Anganwadi Center for a period of 3 months with effect from 21/9/2005, her service was not extended. It was
Yes.
not, Lordship. I have not mentioned, Lordship. My service was not extended. Because this document says my service was extended, and I have been, Lordship, because your Lordship will find at page number Your
Yes.
lordship will find at page number 52.
Hmm. Yes,
Page number 52 of my appeal, lordship.
yes, please.
In continuation of this office order dated 21/9/2005, Srimati Lavanya Barua, Anganwadi helper, Batamari Anganwadi Center is hereby allowed to continue her service in the
Yes.
same post and same Anganwadi Center. Lordship, the engagement is purely temporary and may be
Temporary.
terminated.
Yes, so on an ad hoc basis, you're on some particular date, you're allowed to work. That doesn't give you any right.
Lordship,
The appointment has to be made as per the rules.
Lordship,
You
there is,
can't claim any
there
lien
is
on the
no
post.
specific rule, in fact, Lordship. There is no specific rule provided to
The public
regulate
posts,
the service of an
public
Anganwadi
posts have to
helper.
be,
Lordship.
public posts have to be advertised.
That
Without
was
that,
advertised, Lordship.
yes.
I have stated categorically, Lordship, in my repetition. Your Lordship may kindly come to page number. Your Lordship will find, I have.
Come to para 8 of the judgment. What was the mode of your appointment?
The post of Anganwadi helper worker is to be filled up by following due procedure as per guideline related to selection of Anganwadi workers and Anganwadi helper. None can be appointed to such. That is why, Lordship, I have been appointed in with due process of law, Lordship. It
Let us
is
see
not
that,
disputed.
let us see the appointment order.
Lordship,
Let us see the appointment order.
your Lordship will find my appointment order first at page number 50, Lordship.
Yes.
Srimati Lavanya Barua, wife of so-and-so, Bliss so-and-so, post office so-and-so is hereby appointed as Anganwadi helper, Batamari Anganwadi Center for a period of 3 months. Up to
3
so-and-so.
months. So
Yes.
how was that a regular appointment, gentlemen?
Lordship, that was
Sorry.
advertisement was published, Lordship. But the fact is, Lordship, that if I have been terminated, I have no objection, Lordship. Because unless and until the settled position of law is that unless and until the termination order is communicated
Okay.
and or it is published, it cannot become effective, Lordship.
All right. Okay. Thank you. Rejected.
Keep your right.
Item number 21.
21 has been, 20 has been adjourned. So.
Well, the challenge in the proceedings was regarding a notice issued by the Deputy Commissioner cancelling my mutation, my lord. My lord,
Cancelling your?
mutation.
Okay.
We were, our predecessors were recorded owners
Okay.
of a plot of land.
Or you're not supposed to approach the Board of Revenue? You already been.
Yes, my lord. The issue, my lord, in fact, there has been no proceedings drawn up, nothing, my lord. There was a previous proceeding before the Board of Revenue
Hmm.
where a passing remark was made that the land could possibly be a hot raw land, as in a Vaishnavite religious institution.
Hmm.
So based on that remark, my lord, the Deputy Commissioner issued a notice, my lord.
Hmm.
Now, the learned single judge has held that I ought to have challenged the order of the Revenue Board, my lord.
Yes.
Now, my lord, the two things here. First of all, I was not even a party in that proceeding. And secondly, my lord, the appeal, in fact, was decided in our favor, as in the favor of my brother, my lord. It was just a finding, and therefore I need not challenge a finding per se, my lord. If the outcome is in my favor, then where was the requirement of me challenging that particular observation, my lord? Now, based on that, my lord, the Deputy Commissioner drew up did not even draw up a proceeding, my lord. Straight away, a notice was issued that mine would be
Come to page 7. This court finds force in the argument of learned Advocate General that Act of 1959 provides for an appeal, and in case the petition was aggrieved by any provisions of the Act, he can prefer an appeal under 21(3). Why don't you challenge the order by filing an appeal?
Hello, there is no order to challenge. That is, my lord, in fact, my
You
lord,
say that the Deputy Commissioner has cancelled.
my lord, he
Where is
has
that order?
merely issued a notice. If
Where
your
is that?
If your lordship takes up the page 44, my lord.
Hmm.
In fact, had they drawn up a proceeding, I would have contested it. If notices were issued, my lord, I could have challenged it in an appeal, my lord.
Yes.
My lord finds at page 44, my lord.
Hmm.
This is the impugned letter, my lord.
Yes.
And
So this is a direction for correction of land record.
land
That is an appealable order. If you are aggrieved, go there.
My lord, where do I challenge? My lord, I'm not a party. It's just a letter, a straight
Yes.
direction
So
to the circle officer.
That is for you to decide whether first seek an implement or permission to file an appeal from the competent court and then file an appeal.
My lord,
Why a writ petition is to
my lord,
be
if I may just,
maintained against this order?
my lord, if I may just point out, my lord, the regulations provide for a clear procedure, my lord, where the deputy
Sir,
commissioner.
you are not the recorded khatedar of the land.
I am, my predecessors were, my lord. My lord, if your lordship takes up the record of rights, my lord, my predecessors' names are still figuring in the record of rights. Now, if they want to acquire it, if they want to declare, correct.
Go for a declaration, suit of declaration. Do that. Who stops you? Why a writ?
My lord, this particular letter, my lord.
Yes.
My lord, this is per se without any.
So, all right, a civil court can very well examine. These are all disputed questions of facts. Otherwise also.
My lord, I'm just on the procedural aspect of it. Your lordship will kindly appreciate the regulation. If I may just show the particular power that.
Mr. Counsel, you just tell us, why is this court supposed to examine all these disputed questions of facts?
My lord,
Whether or not the order refers
I'm
to
not
the.
at all urging the
Yes.
court to examine this. I'm only, my limited point is, my lord, the deputy commissioner, before issuing such a drastic direction, at least ought to have drawn up a proceeding as per the regulations, my lord. And at least notices should have gone to at least the recorded pattadar. This is an interdepartmental communication, my lord.
All right, where is the order of the Board of Revenue? And perhaps you will deprive your clients from an opportunity to avail civil remedy also. All right, read the order of judgment of the Board of Revenue.
My lord, page 35, my lord.
Judgment is at page 122.
It has been annexed.
122.
Yes, my lord. Now, my lord, I'll just point out this appeal was regarding a separate controversy altogether. My predecessors were recorded owners. My lord.
All right, go to civil court, seek a declaration that this correction of land record as directed by the deputy commissioner is prejudicial to your client's rights, and this has been done without hearing. So it's
My lord,
illegal.
In that case, your lordship will kindly observe that because the single judge has already given findings that it's a hot roll.
We'll just observe that you can approach the civil court and the civil court will examine the controversy without being prejudiced by the observations of single judge.
Findings regarding my.
Whatever all observations and counsel for this inter-court rate appeal calls into question the order dated judgment and order date 17/1/23 rendered by Leonard single judge dismissing WPC number 3003/2022 filed by the petitioner seeking to assail legality and validity of the order dated (11/4/22) passed by the Deputy Commissioner Barpeta to the Circle Officer Chenga Revenue Circle Chenga. On perusal of the order passed by the learned single judge, we find that certain observations were made by the learned single judge regarding the. But let's see your pleadings first. We don't find that all these things, they were not even argued that your predecessors were the khatedars of the land in question.
Very much part of the record. My lord.
Let's see, where is your argument?
My lord, page 25, if your lordship takes
Read
up.
the argument, please.
The writ petition, your lordship finds at page 7. 95, my lord. 95 is the reply. My lord. 45, if your lordship takes up. Para 2, my lord, at page 53.
Well, this is, gentlemen, this is precisely the controversy before the Board of Revenues regarding the ownership of the land belonging to the
No,
Satara,
no, no,
Satra.
No, my lord.
That's
My
the
lord, the
precise.
controversy was agricultural tenants wanted to acquire ownership on the basis of a special act, my lord. Then the revenue board came to a finding that until original owners are put to notice, my lord, that acquisition.
Come to page 41. From the chitta of the suit land available in the case record, it is seen that the patta of the land is Nis Khiraj
Yes, my
Patta.
lord. That-
Yes.
Yes. Now, my
So
lord,
it is never your land.
no, my lord.
It cannot be disputed now that the land is not Satra land.
Yes, my lord.
Yes, so
No, my lord, that document is already annexed at page 25.
but
It
that
does
is the
not
finding of the Board of Revenue. You have not challenged
No, my
it.
lord, finding of the board, my lord.
Not satisfied at all, gentlemen.
My lord,
Absolutely not.
my lord, I'll just place the background, my lord.
Yes.
We are admittedly recorded owners, my lord. We had agricultural tenants under us, my lord.
Mm.
Those agricultural tenants initiated a proceeding to declare that they have acquired ownership rights
Mm.
on the basis of their long tenancy, my lord.
Yes.
That the deputy commissioner thereafter ordered that recorded owners should not be there. These tenants should step into the shoes of the owners, my lord.
Yes.
Against that, one of my cousin preferred the appeal. In that appeal, my lord, that appeal was decided in our favor, holding that.
Not in your favor.
My lord, I'll just.
Not at all.
My lord,
You are
in that-
mistaken. You are gravely mistaken if you
And
believe that.
that particular judgment is pertaining only to 17 bighas of land, my lord.
So that is their claim for 17 bighas.
My
But
lord,
the Board of Revenue says entire chunk of land, total area of the land in one NK patta of the village, so and so is 101
Well,
bighas, so and so.
my lord, that is just one of the reasoning offered to decide the appeal in our favor, my lord.
Not in your favor, gentlemen.
My lord, the order that was impugned was set aside and it was held because your lordship will appreciate we are also successors of the Shebayat, my lord.
Is it DT land? DT land can't be vested in any
My lord,
private person.
whatever be it, my lord, we are
That is
recording
settled law.
owners that is established, my lord. In fact, the
DT
revenue
land,
board did
gentlemen,
not-
go read judgment of Rajasthan High Court full bench, Tara versus Board of Revenue. DT land cannot vest in any private individual. Settled law. If you want, we'll make observations based on that judgment. Or else the learned single judge has given you liberty already. Avail that liberty.
My lord, learned single judge has already held that it's
That is simply reproducing from the observations of the Board of Revenue.
precisely my point, my
Yes.
lord, that revenue board judgment is not even binding upon me. I was not even a party there.
Speak a declaration to that effect.
My lord, so your lordship will pass that initial order your lordship was contemplating to pass, my lord.
No, absolutely no. All right, come back after better preparation. List after 6 weeks as great.
Obliged.
Board Pujari, read a Rajasthan High Court full bench judgment.
Yes, yes.
Tara versus Board of Revenue.
Yes,
A
yes.
celebrated judgment.
Yes, yes. How the genealogy?
DT land cannot vest in anyone
Yes,
else.
there is no issue of genealogy. One cannot impute genealogy of person and nature. That is the clear finding. I am so obliged.
Item 22.
Yes.
Lordship, that respondent number 4 was supposed to file.
Lordship, in this case, Lordship, I pray for some more time, Lordship, because the counsel for the respondent number 4 is on bereavement, Lordship. They have asked me to pray for some more time, Lordship.
Last date, Mr. Botakur appeared.
Lordship, I am on behalf of him, Lordship.
Mr. Botakur was here in the morning. No.
No, Lord.
He's a different board.
Different Bota.
Different board. He's in bereavement.
Okay. It is stated that land council representing the respondent number 4 is in bereavement and some more time is sought for so as to file affidavit on behalf of such respondent. Last opportunity of 4 weeks is being granted for this purpose.
The learned counsel for the petitioner has filed a reply of affidavit in opposition filed by the respondent number 7. A copy may be served of it.
Give a copy.
Item number 23 to 25.
My lord, by order dated 26/7/23, Lordship said that they will await the reference order, my lord.
Reference.
In one of the case, my lord, it so happened whether notice is required to be given under Rule 18 or not. there is a reference to larger bench. The Lordship
Pending,
says-
pending in this court.
Yes.
That case was referred to the Honorable Division Bench, Your Lordship, right, order dated 26/2023. Lordship, that has not been listed yet.
We'll ensure that.
Honorable Division Bench.
Yes,
Perhaps we may have to wait, my lord.
And
all right.
yes, Lordship, regarding
The reference on the question regarding notice to encroachers under Rule 18 of the Assam Land Revenue Regulation 1886 has still not been decided. Thus, the consideration of these PILs is deferred by 8 weeks, awaiting outcome of the said reference. The registry is directed to list the reference before the larger bench at the earliest.
also,
Deep
Your
level.
Lordship, regarding the status report of the other revenue circles where encroachment has been identified, Your Lordship. As per my telephonic instruction, Your Lordship, regarding the eviction.
So why don't you file it on record?
Yes, Your Lordship.
MS Bodlai, in the meantime, MS Bodlai shall file the status of encroachers in the other revenue circles. And the status taken by encroachers in the other revenue circles across the state of Assam.
No, Your Lordship, only this Kamrup Metro.
Kamrup Metro, okay. The revenue circles of Kamrup Metro.
Obliged.
So this is PIL and writ appeal both. Writ appeals and PIL, so.
Item number 26 to 28.
Very to your lordship. Which over here, lordship, recently the state respondents have filed an affidavit in opposition, lordship. The state respondents have filed an affidavit in opposition, lordship. I want some accommodation lordship, to file a reply, lordship.
Affidavit in opposition has been filed on behalf of the state respondents. Counsel for the petitioner, praise for and is granted 4 weeks time so as to file an affidavit in reply thereto.
Obliged.
Supplementary list, item 30.
So you never turned up again, gentlemen. We called out your matter twice. Yes.
Mr. Ganguly is on legs in another court. Kindly
Oh, doesn't matter. Yes,
Lordship, we have given over the peaceful position of both Schedule A and Schedule B.
already given.
Yes,
So
Lordship.
then what survives in your petition?
Lordship, the thing is that Schedule A, Schedule B property was not auctioned off.
So you raise your objection, go to the DRT.
Lordship, actually the auction has been done, Lordship. The first schedule after the auctioning of Schedule A.
We are asking you, what about the Schedule A property?
Lordship, Schedule A property has been given over.
When?
Yesterday, Lordship.
Yesterday?
Yesterday. So, Lordship, Schedule B property need not be taken over.
All right,
So
pass
that may
over.
be released.
Pass over. Or list on 17th. Then counsel for the petitioner makes a statement that possession of Schedule A property has already been handed over to the respondent bank. List on 17th. So as to enable the counsel representing the bank, Mr. Ganguly, to complete his instructions.
Lordship, till then the Schedule B property.
Till then, in view of the, this fact is not disputed by Mr. So-and-so, associate to Mr. A. Ganguly, representing the respondent bank. In view of the facts noted above, it is hereby directed that that since all the outstanding amount, the entire outstanding amount toward the loan account has been covered, seems to have been covered by the value of the Schedule A property, it is hereby directed that the Schedule B property shall not be auctioned till next date. List on 17th.
Obliged.
Item 31 for final disposal.
Wait, Your Lordship.
Yes.
The issue is basically that I was settled with a particular fishery. Now, the government have held that the private respondent, he was a defaulter of a particular amount of money, which has now also been established.
Yeah.
Now, based on that, his claim was turned down, though he was a higher bidder, but it was found to be defective because he was a defaulter and it was settled with me. The matter went to the single judge. The honorable single judge have held that since the record does not throw light on the fact that he is actually a defaulter, so therefore a mere observation by the government while evaluating will not help.
Okay.
And based on that, my settlement was interfered with and the direction was issued that it may be settled with him.
But you are enjoying a stay.
No,
No, then he's
he
running.
is, he is enjoying it.
All right. What do
Being
you
a defaulter,
say?
He's enjoying it. And in this writ appeal, I have also brought that document on record whereby it is clearly evident that he was a defaulter. Therefore, the government stand in evaluation that he was a defaulter stands. Today, he has filed additional affidavit wherein he also admits he was a defaulter. But his case is that I had raised some appeals on that. It has not
Doesn't
been.
matter. The fact of default is admitted. What do you say?
No, my lord. Fact is, my lord, in 2018, my lord, the government issued a letter, the entire fact was, my lord, audited. Not only my.
Simple mathematical question, whether your client was a defaulter or not.
No, according to you, no, my lord.
Oh,
No, my
okay. Okay. Let's see the comment stand. Where is your affidavit? You filed it today.
If a lordship will take up the IA 3802. It was running page given.
And in fact, my lord, we have
IA 3802.
instruction that has been placed in the earlier occasion.
Yes.
The respondent is defaulter and has deposited. Why he is saying so, my lord, I don't know.
He has deposited amount towards the default. Yes.
No, no, no,
There's
not
a-
that, not 4 lakhs, my lord. My lord, there is a defaulting amount of rupees 3,59,000.
No. The amount is much more as per the comment.
No, kindly, my lord, see my affidavit, my lord. I have filed.
71,000.
Yes.
In that regard, my lord, I.
Annexer 1 of the IA. shows the
21
clarity.
lakhs is
No,
the
my-
total defaulter.
My lord, kindly see my additional affidavit, my lord, page 80.
Yes, please.
Page 80, my lord. Kindly. Well, this was written to me by the Deputy Commissioner of Nagaon, my lord.
Yes.
So the NIT was of 2017. So he must show his position 2017.
Yes, that's
not
right.
thereafter.
That's right.
Kindly let me. My lord,
I have to put a clarity on that.
this is to inform you that the senior accounts officer filed his letter number so and so submitted a detailed report outstanding dues of fisheries mentioned in para 18 of the report against the society name there, and hence you are hereby asked to deposit the said amount within 7 days for treasury salary. A Xerox copy of para 18 of the report submitted by senior accounts officer is enclosed herewith for your needful. Therefore, you are hereby asked to deposit the same amount mentioned in the report para 18 within fixed time. Otherwise,
There's a very crafty reply. No outstanding dues of KIS towards the running of the Sonai Nadi Part 2 fishery.
Yes.
It can be an outstanding towards any government dues. That
Yes.
is what the requirement is. So it's not only for that particular fishery. The outstanding must not exist for any government dues. That is what the requirement of law is.
My lord, in para 18, my lord. Page 82.
Just hold on, sir. Come to annexure 3, page 86. The dates are very relevant. When did you pay? The outstanding amount was for the years 14, 15, 16, 15, 16, 16, 17.
Yes.
And
3,59,000 according to them, my lord.
yes,
We have filed a representation before them that according to us, my lord, we have not liable to pay any money.
yes, then why
So
did
that
you
is why, my
pay?
lord, the government fixed a hearing, my lord, at page 87. So that
Yes,
hearing was not taken place till today, my lord. If I pay rupees 3,59,000, my lord, I will pay it, no problem, my lord.
it doesn't matter, but fact remains that this is a default notice to you.
Yes.
That is what is, how could you have procured a Bakijai certificate?
No, my lord.
Yes,
We
no
have,
dues.
we have.
You are required to
we have-
submit a no dues.
My lord, we have reply our.
The government, just hold on, sir. The government cancelled or rejected your bid on the ground that you are a default.
Yes.
Did you file a Baki no due certificate?
No, my lord, at that time, my lord, my tender was not my lord, rejected only for default, my lord.
So we'll finally see page 41. The reasonings given, page 41.
41.
Page 41, serial number 2. Ganesh Chandra Das.
Yes.
Page 41,
Yes.
serial number 2, Ganesh Chandra Das. The last line, besides the society is a defaulter of government revenue, as per observed by the tender committee.
Yes,
Hence the
yes.
tender is rejected.
Yes.
This is the observation and
My
therefore
lord,
it was
kindly see
rejected.
page 39, my lord.
Yes.
Page 39, my lord. Serial number 2, Ganesh Das, my lord.
Yes. Read.
This was the order of the government.
My lord, this is, everything is okay, my lord. In my tender, everything is okay, my lord. Everything is okay, my lord. Since I
This
have.
doesn't
started-
deal with, this doesn't deal with your default.
No, my lord, if I defaulted any default amount, as per the report of the, my lord, senior accounts officer, we'll pay it, my lord.
No, we will,
Matter.
doesn't mean anything. You
Mother-
couldn't have been granted the fishery in question. There's no question. No question
Mother-
at all of you being granted the fishery.
My lord, we have filed representation on that representation, my lord, there is a date for hearing. And no hearing was taken place till today, my lord.
Yes, yes.
So let be directed to, my lord.
Now the government's letter says the total default is 21 lakhs.
No, my lord, how it can be done? The
Yes.
accounts officer report is false then, my lord. Which will be true, my lord?
You have been
Accounts
given a
officer says-
copy? You have been given a copy?
Yes, my lord, accounts officer says, my lord.
Just hold on. Have you received a copy of this letter dated 2nd August 23?
Yes, I have.
Yes,
On-
what does it say?
On that, my lord, I have filed an additional affidavit, my lord.
Yes, read.
Yes, my lord.
Ms. Sharma, why do your officers move in this manner? The notice which has been given is of 3,59,000.
Yes.
And herein you say default from 2005 to 17.
There may be, my lord, regarding that, my lord, maybe, my lord, regarding one fishery and total dues in the for the, my lord, respondent, that may be, my lord, 21.
Lordship will therefore see that IA Annexure 1, the Deputy Commissioner Nagaon has given the entire calculation. That IA 3802, Lordship.
Yes.
3802, Annexure 1.
Annexure 1.
Annexure 1. This is by the Deputy Commissioner Nagaon. He gives the entire calculation and that amount comes to 2171.
Yes.
So this is the entire calculation of default. So the fact remains that on the day when he submitted his tender 2017, he was a defaulter.
He was a default.
And
All right.
therefore, based on that, it was rejected. The honorable signatures, however, held that the records do not put clarity on the fact that what were the documents and therefore negated that aspect and said no, it can be allotted with him.
Okay. Anything else to say, sir? Yes,
So
counsel.
single judge observations are found at page 66.
66. Read. Tara?
Paragraph 14. Page 67, if a lordship will see, the relevant portion is 67, the learned government advocate in the middle. The learned government advocate has also not been able to show any document from the records which discloses the government revenue due from the petitioner. In paragraph such and such, the petitioner has specifically denied any liability against the government revenue and the said assertion by the petitioner has not been specifically denied by respondent number 2 in the affidavit. Therefore, applying the doctrine of non-traverse, the allegations against the petitioner as the defaulter for paying the revenue falls flat. So this was the observation. And the government affidavit also clearly states that he is a defaulter.
Where is the affidavit? Let us see.
Yes, Lordship. The government affidavit, Lordship will find at page 55.
55.
Before that, one document I would like to show your Lordship at page 50. It will kindly come to page, or in fact, page 52. Page 52, Lordship, Annexure C. This was written by the additional Deputy Commissioner Nagaon to Ganesh Chandra Das, the present private respondent, asking him to pay those revenues, the non-payment of revenue. This was on record.
16 lakhs.
Yes, at that time, 16 lakhs. And thereafter, Lordship will kindly come to page 54, is the affidavit of the government. where the
Revenue amount is yet to, 25 lakhs is yet to be paid.
Yes. The amounts keep on recurring and interest are also added, but the fact remains a defaulter. And page 54, if a lordship will come to the affidavit by the joint secretary, therein at paragraph number 8, the last line lordship will see, paragraph number 8, page 55, last line, beside the society was a defaulter of government revenue as per observation tender committee. So it was also in the affidavit by the government. But the fact record, the fact was that, however, the records that relevant.
Did they file any affidavit in reply? After that? No.
No.
Oh.
They are never denying this fact. They are only they're disputing on the amount. Therefore, he has made some part payment also. So on the day when he submitted his bid, he was a defaulter. That is my entire case. So therefore, the government's observation was correct. And the official was rightfully had settled with me. Now I am been deprived of the settlement. He's enjoying for last almost 2 years.
Reply to that, madam.
Let's see, we have what page?
We have filed reply, madam.
Where is that page number?
In the writ petition, my lord.
Yes.
আমি আমার reply to it. Paragraph 6, my lord.
Read.
With regard to the statement made in paragraph 8 of the affidavit in opposition filed by the respondent number 2, it was stated that the petitioner society that the Puri Satra Maspura Samay Samiti Limited did not submit the neighborhood society issued from the competent authority based concern circular. In this regard, the petitioner society states that the petitioner society annexed a copy of neighborhood certificate issued by the Assistant Registrar of Cooperative State Assam, which is annexed in the writ petition as Annex 2. But the tender committee, the tender clause who no such requirement was mentioned. Further, the petitioner states that the society is not a defaulter society as alleged. It is incorrect statement made by the respondent just to support the settlement of the private respondent. My lord, my submission is, my lord, my earlier settlement period was, my lord, 6 to 2017. In that period, my lord, not only my society, some societies were my lord, remain unpaid their kiss money.
Yes,
But-
so a defaulter
No,
cannot be granted settlement.
my
That is a
lord,
settled law.
my lord, that is why, my lord,
Yes.
the government made an audited report, my lord. In that audit report, my lord, we are informed that we are liable to pay 3,59,000.
Yes.
On that case, my lord, we have submitted a representation. On the basis of my representation and
Listen,
reply, my lord,
gentlemen, on the date of settlement, your amount may be written off later, but as on the date of settlement, you were a defaulter, which fact cannot be
no,
disputed.
till that,
We'll
my
pass the
lord,
order, okay.
till that, my
Thank
lord, I was not declared defaulter, my lord.
All right, thank you.
Obliged, Your Lordship.
Argument heard, order is out.
Obliged.
My lord, one thing, my lord, I am submitting, my lord. They are running more than 4 years, my lord. In that particular 4 years, my lord, they are remaining, they are also defaulter of.
All right,
rupees 6
government
lakh,
will
my lord.
take, government will take
6
action.
lakh, my lord.
His
Government will
settlement has to
take-
be interfered with. I will be given. an
Government,
order
will- if
depend
he is
upon
a
my
defaulter,
position.
action will be taken
Yes,
against him also.
obviously, obviously.
Yes, my lord.
On that
Go
basis,
for,
he
my
cannot
lord,
continue.
fresh settlement, my lord. Fresh settlement will be directed, my lord.
Now it's almost 6 years since the settlement was done. We'll direct a fresh settlement.
Yes, my lord, that is
Let
true.
them
Yes.
take a call on that. If I am a defaulter, because that is not an issue before the office.
We'll quash his settlement.
Yes.
Direct to fresh settlement.
And direct the authorities to take a decision on merits, Lordship. In that view,
Let
because
fresh settlement be
Yes,
taken.
fresh settlement, my
Now
lord.
it's too late in the day.
1 year is there, Lordship.
Fresh settlement will be directed, my lord.
In my humble submission, the authorities will be directed to take action as per in accordance
No,
with
no,
law.
we-
In
we-
my humble submission, I
No.
leave it to your Lordship,
Fresh tender would
because
fetch more money to the government.
Yes.
So fresh settlement. Okay, thank you.
Obliged, my
I
lord.
leave it to your Lordship.
Daily list, item 1.
Your Lordship, as per the last order, I had prepared a short brief and the same has been circulated to the other side and to the bench as well, Your Lordship.
What is your grievance in this petition?
Your Lordship, here in this petition, the government of India came up with a nationally health insurance scheme, which was known as Pradhan Mantri Jan Arogya Yojana. In short, it was known as Ayushman Bharat. So this Ayushman Bharat was based on socio-economic consensus 2011. But at the same time, the government also did a population census 2011. The population census 2011 talks about that Assam has a transgender population of 11,374.
Yes.
Whereas the socio-economic caste census is divided into two parts, urban and rural. And urban and rural says that the Assam has a transgender population of approx 1,200 or 1,500, which is contrary to the population census of 2011. And why this socio-economic caste census is important? Because based on the socio-economic caste census 2011, the government has implemented to the person who are being included in this socio-economic caste census. And according to that, non-gender binary norms, all the male and females were being included in this scheme. But simultaneously, the transgender persons got left out.
Got left out.
Got left out.
Okay.
However, the state government has included the transgender persons under Atal Amrit Abhiyan upon my repeated request. But why the discrepancies is there? The discrepancies is Atal Amrit Abhiyan is related to only 12 critical care. A person may have or may not have those critical disease.
Yes.
But whereas in the Ayushman Bharat scheme, it is a very wide package and procedure pertaining to the health issues of the transgender community.
So basically your prayer in this petition is to rectify the error in the caste census so as to account for all third category, third gender persons. That is what the prayer.
Our main prayer is to include the transgender persons under that scheme first.
Okay.
Then our
So who is denying that? Are they being denied the benefit?
yes,
How do you say?
because in their affidavit, your lordship will find they have included 5-6 persons. We never know that where that ever they are from the community or not.
5-6 persons in what?
Only 5-6% in the Ayushman Bharat scheme.
Only 5 to 6.
Only 5-6%.
So
That is
you
what
tell us, you
contradicts.
tell us. Has there been any exercise by the transgender persons to be included in the Ayushman Bharat scheme? And has there been a denial? You know, someone applies under that category and there is a denial. That gives rise to an apprehension. Without that being, how can we prejudge?
Now, initially, your lordship, when this entire scheme was rolled out, there was also an online procedure that was introduced by the Ministry of Health and Family Welfare Department. Simultaneously, on that initial stage, the gender column has only male and female.
Yes.
So we couldn't apply even
Obviously,
for that.
but whether that
under
has
that
been changed
category.
later?
Yes. And after filing up of this PIL, now they have come up with an extension of the gender column, now male, female, and transgender.
Transgender. Okay.
But more importantly, what the government has did is the Ayushman Bharat benefit will be extended to the persons who have a ration card.
Okay.
Now, many of the transgender persons who are being left out from their homes, who are being dissolute by their own parents.
Why can't they have a ration card?
I don't know. That is the state government has to answer.
Are these issues forming a part of this petition?
Yes, your lordship, pleadings after pleading. That is why I have created a short brief.
Yes.
Point wise, referred.
Read one by one.
Yes.
First, you said that column has now been incorporated, but for an agreed person to apply, the person has to have a ration card. Where is that requirement?
That requirement, the state government may say, because the notification is
You are
not there.
saying that person not having a ration card can't apply under the Ayushman Bharat.
No, because why I'm saying this, your lordship, in the Guwahati Medical College, when I last visited, they have in the OPD sections, they have the center of Ayushman Bharat.
Yes.
So when I took 2-3 transgender person, including me, so when I said that we want to make a Ayushman Bharat card, the authorities who was looking after all those procedures for issuing of that Ayushman Bharat, they said if you have a ration card, then only we will be able to
proceed one by one. Today we make an observation in the order on your oral submission that the persons of the TG community are not being included in the Ayushman Bharat scheme on the premise that they are not having the ration card. Let them come out with the response. If it is a negative, we'll issue a direction, right? Secondly, tell us, what is the mode of being certified as a third gender category? Who issues that? Who gives that proof? Any person posing to be a transgender can go to the hospital and say that I want a reconstructive surgery under the Ayushman Bharat scheme. How do we govern those things?
Section 6 and 7 of the Transgender Act 2019.
Yes.
Section 6 talks about if you are a transgender, along with that medical documents.
Medical, that is what we are asking. Who issues the certificate?
District magistrate on the basis of the psychological evaluation and psychiatrist
So
certificate.
that is the answer to your issue. We can clarify that if the person is carrying a certificate issued by the competent authority, then the person will not be denied the benefits of the Ayushman Bharat scheme. Only on the ground that the ration card is not available. Would that serve the purpose?
Yes. No, but your lordship, in the act, it says to avail the various government, state government and central government policies and schemes, ID card and certificate is necessary.
Yes.
So now many of the transgenders, they have applied and they have obtained for the ID card and certificate from the
Yes.
district magistrate.
So that should be sufficient
That
to,
should
so
be
to be enrolled in Ayushman Bharat. Why
Yes.
not?
Yes, that is why in many
So
of
we
the,
we'll make that observation. Let them come out with a response
Yes.
that a person carrying a certificate and the ID card, if required, if medical attention is required, such person should be enrolled in the Ayushman Bharat scheme.
yes, on the
So-
basis of that ID card
That
and
ID card.
certificate.
So let them come out with a response.
Yes.
Okay. That is one. Second,
The second is your lordship,
now take down first. The petitioner present in person submits that the persons from transgender category are not being enrolled under the Ayushman Bharat scheme, and thus, they are being deprived of the benefits of the scheme.
6 and 7.
This court is informed. Let us have the act, please. Act of 2019, that for a person to be identified
5, 6 and 7.
as देना ना photocopy दे दीजिए.
Section 5, 6 and 7.
We may note that the chapter 3 of the so and so act deals with recognition of identity of transgender persons. Under section 6, the district magistrate is empowered to issue to the applicant under section 5 of the act, the transgender person can make an application to the district magistrate for issuing a certificate of identity as a transgender person in such form and manner and accompanied with such documents as may be prescribed. The district magistrate is authorized under section 6 of the act to issue to the applicant under section 5 a certificate of identity as a transgender person after following such procedure and in such form and manner as may be prescribed, indicating the gender of such person as transgender. The gender under section 6(2), the gender of transgender person shall be recorded in all official documents in accordance with certificate issued under subsection 1. Subsection 3 of section 6 provides that a certificate issued to a person under subsection 1 shall confer rights and be a proof of recognition of his identity as a transgender person. We feel that any person possessed of a certificate issued by the district magistrate, certificate/identity card issued by the district magistrate should be extended the benefits of the Ayushman Bharat scheme. However, the petitioner submits that when an effort was made by certain transgender persons to procure the benefits of this scheme at the Guwahati Medical College, they were denied on the ground that they were not possessed of ration cards. The Government Council, Mr. Bora, shall take instructions on these submissions of the petitioner and submit the response of the authority concerned by the next date. Now come to the second.
Now, today we need an urgent direction as per section 15 of this act, Your Lordship, that are required to be made to the state government.
What is that?
Section 15 is relating to the healthcare facility.
Mr. Bora
In the-
shall also.
In the meanwhile, they may do the necessary procedures that may be required for inclusion of the transgender community in the Ayushman Bharat scheme. But at the same time, on the last date also, and there is an affidavit placed on record that the Guwahati Medical College has came up with a 6-room ward, including toilets for the transgender community. So now what we want is, at least section 15 is required to be adhered with, so that at least in case of emergency.
Mr. Bora shall also apprise the court regarding the steps taken at the Guwahati Medical College regarding compliance of section 15, mandate of the section 15 of the Act of 2019. For the present, this will suffice.
Yes, because all these things. are
We will,
one section.
this is a comprehensive order.
Yeah.
Re-notify on, whenever we place those matters on
time.
7th,
9.
9th November. Okay.
Lordships, may I make a small prayer? Lordships, I have been, the Assam State Legal Service Authority was implemented as a party respondent in month of February by our Lordships. Lordships, I'm not really aware as to the terms of reference of why we have been incorporated, and hence I've not been able to.
You act as an amicus. Whenever the petitioner's counsel requests you to visit the Guwahati Medical College, assist. Okay, provide assistance. That's an oral observation as an officer of the court. Okay. Nothing adversarial in this case.
Because I was not.
All for the benefit of seriously deprived persons.
And your lordship, one last observation, if your lordship may just make,
Hmm.
that the state government also will come up with an instructions that for setting up of necessary medical welfare board for transgenders. Because why I'm saying this, because your lordship will find in many.
Let us get
sexual-
compliance of 2 directions. We'll go step by step.
No, why your lordship, I said this, because naturally we all knows that in the sexual assault and in the rape cases, the medical board is required to be constituted. So also for the healthcare of transgender persons, there has to be a medical board.
Under what provision? Why do you need when there is a separate board that will take care of everything? And if section 15 is complied with in the letter and spirit,
Yes, yes.
this would take care of everything. Welcome. 9.
Item number 2.
Please, your lordship. Lordship, regarding memo, lordship, we are extremely sorry, lordship. So, lordship, I apologize for that. Otherwise, I had taken concern of my brother, lordship. My lord had directed us to file a short affidavit, lordship. We have received the instruction, lordship. The instruction says that, lordship, in academic, petitioner is benefited, lordship. Academic. And otherwise also, lordship, one thing is there was that particular selection was abandoned, lordship. And another selection was also done. Petitioner also participated that selection. I will bring it on the records, lordship.
Okay, Land Counsel, Mr. Gogoi. Raise for short opportunity to file an additional affidavit.
Lordship, affidavit, lordship.
Affidavit in terms of affidavit in this matter.
Lordship, lordship.
List on 14th November.
Lordship, lordship.